Hello, I'm Angela Princewell,
And I'm Shireen Abdi.
and today we're going to be talking about decision-making responsibilities in cases where the parties are extremely high conflict. And Shireen, I know you had the question recently where a client was wondering if their matter is high conflict, does that mean your client gets sole decision-making responsibilities for the child?
So, in a short answer, no. And the court deals with this in a multitude of ways, right? Sometimes a lot of the people might, inflate issues to make it seem that, maybe there is, in fact, conflict, or just maybe there is a lack of proper communication. And so long as there's parameters set in place, such as, maybe both the communications would be, through a third party app, or that, those communications remain respectful and child focused. So that might be a situation. A lot of the times people just think, well, we don't get along, so I should have sole decision making ability because that's just how it is. Unfortunately, that's not how the court's going to look at it. So, among, setting up some parameters for communication, the court also might look at, decision making. If there is issues in getting it to a decision, they might set very strict parameters, such as, maybe having days where, you consult. If you can't, you would go to, a parenting coordinator, a third party, or a mediator, arbitrator, someone else to assist in making that decision. Or you guys can have something like split decision making, or parallel decision making, which is that, and looking at different decisions. So I'll just use four main ones, which are decision making respecting medical and healthcare, education, extracurricular activities, and religion. Maybe, you guys could split it. So parties can have two areas and the other party can have final decision making on two areas. Doesn't mean that you wouldn't consult with the other party, but it would just kind of alleviate some of that contention. So yeah, I think I went along a lot of examples, but if we kind of like break that down, we could do that too.
Yes, actually, I picked up on a few things when you were speaking, and I would like to go back first off with sort of the starting point always being what's in the best interest of the child. So when we're talking decision making, the whole idea with high conflict is, are you guys able to still make decisions that are in the child's best interest? And I think that's ultimately when your clients say, well, I should be the one making the decisions, is because they're thinking, well, that's what's better for the child, but not, we all know that doesn't necessarily mean that your decision is right. And sometimes it's good to kind of get that balance. But I'm going to come back to the best interest of the child, because that's something we need to kind of spend some time on. But I want to pick up a few points that you mentioned. So one is the parenting coordinators. And I just want to put it out there that it is controversial. There is no, the ability of the courts to order a parenting coordinator is not, it's not clear. I should put it that way. I don't really think, in my opinion, that the courts have the jurisdiction to order that the parties have a parenting coordinator or arbitrate an issue or whatever. If the parties, of course, agree to it, then that's a different scenario. So I didn't want anyone kind of misunderstanding
No,
that. Yeah.
Yeah, so I was just saying in the framework of that, of course, it can be ordered from the court's perspective if the parties like agree, of course, but that's one workaround as to high conflict scenarios.
Yeah. But I've also struggled with it, to be honest, in some high conflict cases, because I mean, especially with parties with more modest means. I've had clients that there's so much conflict that I don't even want to give them that opportunity. And I can see how that's sort of a workaround, because, if you have an issue and you go to someone to kind of break the impasse, but some people argue over almost every single thing, that all I can see is the dollar signs, and I can just foresee this costing them so much. And then sometimes they would say, well, we can apportion costs or whatever to be able to take, maybe caution people a little bit. But then then there's the argument about costs. And so anyway, it is one workaround, and it is, I just wanted to put that out there, that the parties kind of need to consent to that. But before I talk about split parenting, because you did throw in a lot of useful ideas out there, I just want to go back again to the best interest of the child analysis, right? Are you able to see where it's in the best interest of a child for parties that are in high conflict to still consult with each other before decisions are made.
Absolutely, especially if one is heavily involved, right? If they've shared that, responsibility, they are able to meet, day-to-day needs. There should be a level of involvement for both parties. It shouldn't just be that one party makes the decision. There's also situations where there's cultural impacts, some religious even. So it is important to have both parties at least consult with each other on decisions that affect the child. Maybe, they're of different religions and they're agreed to raise their child a specific way, or from a cultural perspective, they want exposure to all of that, the different cultural competencies and all of the different issues that come into play with that child, growing and developing, but, still maintaining that meaningful connection to each parent. So it is something like that. I think it's very useful. Of course, why a court would, or why it's appropriate, in the circumstance, why, you would want joint decision making.
Absolutely. I agree with you. And I've even seen cases where, interestingly, the parties are very high conflict, but have somehow managed to make decisions jointly over the years. And that's a factor that a court would consider when deciding on kind of what should happen going forward, right? And I mean, so I know a lot of times, yes, it would just be easier to say one person have final decision because it makes things easier for everyone. But if things have kind of been working out with both parties involved, obviously one person might be the more dominant person in terms of moving decisions forward or making final decisions. But at least if there's a history of decisions being made jointly, then the court, and if all of the decisions that have been made have somehow been good for the children, then the courts, the fact that the adults cannot stay conflict free the courts would not necessarily change decision making just so that it's more convenient for one person. Sometimes it's also just more of an irritation. You just don't want to have to talk to that person anymore.
And I've definitely made that argument before too. Like, the fact that we are where we are, there's only so many decisions that are so important that you would have to do, you would have to be on the same page of. And so realistically, there's never usually, I'm not saying there's never usually conflict, but in terms of major decisions, there's not many that people would have to make in their children's lifetime that they couldn't make. Of course, like every circumstance and case is different, but and that's sometimes the court would also ask, like a judge would say, well, how many, they've been separated for X amount of years, how many decisions realistically have come up and that they've been problematic? And for the most part, they're usually not a lot, or if any. Right. So that's a big factor, right?
Oh, and I love that you said that.
A form of irritation that someone just doesn't want to have to do that. And that's fair, especially if you're leaving, an abusive relationship, if you're, you have an imbalance of power, or there's just someone who's just difficult to deal with just simply because they don't like you, or it is high conflict, of course, but that's not going to be the only reason why, they're going to apportion one party final decision making and not the other.
I think I like what you said there about how often do these happen. And I find that for me personally, I'm more concerned about my clients getting as much parenting time as possible, because I just personally believe that a lot of day-to-day decisions have a higher impact. So for me, if in terms of involvement in shaping a child's life, a lot of times you pick the school that's in the area where the parents are living, and then they continue through that elementary school into the high school that's closest to them. There's very few times where, the parties really stop to think about something else. So it does depend. Of course, you did say case by case. So if we have children that maybe need, some kind of individualized education program, for example, and the other party is not cooperative, then I can see where that would be a concern, or if there's serious medical issues that are being minimized by another party. But I found that the judges, like the courts, and even with a lot of lawyers, we're finding ways around this rather than just defaulting to one person having sole decision making. I've had cases where, in terms of education, we're like, well, we'll just listen to what the school, follow the advice of what the educators say, right? And that's just like common sense. They're working with your kids all the time.
Absolutely. And that's actually a most common one, right? We'll leave it up to the professionals when it comes to medical, when it comes to education, because there are individuals who are better in the capacity to better assist. If they do have recommendations, it's to utilize those recommendations first and then try to get an agreement based on the advice that you have from obviously the teacher, support aid, dentist. I mean, imagine like a dentist is fairly simple, but still, any other,
But I mean, therapy is a huge one, though. I find that a lot of times we find conflict with parents, one parent not agreeing to therapy, and that's one huge reason why people come to us, wanting us to help them get sole decision making.
Yes, and interestingly enough, it's also been it's an important issue as well, because not only do you need the consent of the other party, depending on the child's age, you might also need the child's consent. So you're dealing with kind of a double whammy in a situation where it's very clear that your child might need, some therapeutic interventions, but they're over the age of 12, they also need their consent along with the other party. So you need to be on a united front. And of course, when you have a very high conflict situation, it can be a little more challenging, of course. But yes, I do find that like therapy is usually some form of contention, because some people are not receptive to it and others, just simply don't agree.
Yeah, no, true. Even activities is one that comes up less often. I find that when it comes to extracurricular activities, most times parents would follow the lead of the children. But there's been a few times where there's conflict, some sports that parents will consider dangerous. I'll raise my hand to football if we're picking.
I find most of the decisions come with the financial, repercussions of something like an expense. But yeah, I do hear like, if you're putting into like football, it's depending on how young the child is, like a lot of parents, given like, the medical feedback that's been going on, they're not happy with that. Obviously, sport versus like contact football or, soccer are a little different in terms of like, what would happen. But realistically, yeah, I see what you're talking about.
I like that you mentioned cost, because when we think, that's a huge reason why people may not agree. And so I think it's a misconception to think that because you have sole decision-making responsibility, you can just go ahead, put the child in an activity and pay. And I have had to argue this at motions where, parents, and I did have a judge actually challenge me on it and say, well, did mom really have to tell dad about this activity when, she does have sole decision-making responsibility? And I'm like, absolutely, because the case law is clear. If you want the other party to contribute, so there's two aspects to it. Yes, you can exercise your sole decision-making responsibility and put the child in, soccer or whatever, and you pay all the costs, and that's fine. It's your, court-ordered right. But if you're going to be asking the other party to pay, then you need their consent. That's something that you need. So I'm glad that you mentioned that, because I don't want anyone thinking they could just, get sole decision making, go ahead and do whatever they want and expect to get a blank check from the other person, right?
No, absolutely. That happens often, and it can be significant too, right? Because it's not just consent. Sometimes you have to look at both parties' resources. So Section 7's a point of contention. Religion also comes up a lot, like in terms of contention. Of course, if they're definitely, when you're separating, and maybe if the child's young and you both have different religions and you want, the child to be raised as one religion but you both want exposure, it really just varies on a case-by-case basis. But there's so many workarounds to all the decisions. Like we get kind of creative when it comes to drafting, so long as it's workable and we understand on a case-by-case. We can't just just say they'll consult with each other. If they don't hear back by so and so date, you'll be able to make the final, or the party seeking a decision will be at liberty to make that decision. That's all well and good, but and those are maybe for more like non-responsive partners. Some people, I find that they just want to make sure that they don't relinquish those rights, not necessarily having an issue with the other person's decision making, but they just don't want that decision to be taken away from them. So another way of making sure there's some compliance, we add, timelines, we set parameters, so that way we're not leaving, the child without a decision to be made and the other parent without proper recourse.
Absolutely. No, I hear you. That exactly. I mean, I couldn't add anything further to that for sure. So, I mean, when it comes to, I think if there's anything we want you to take away from today is that the fact that you don't agree with the other person, they're difficult to work with, there's such high conflict, doesn't necessarily mean that one party will get sole decision making. And but on the flip side, if one party is to get sole decision making, it may not be you. So be very careful what you wish for, because the courts may find that you're the person that's creating the conflict, and they might find that your decisions aren't necessarily in the best interest of the child. So what you just always have to remember that when you put something before a third party, they're not going to interpret the information as the same way you think, right? You presented, the other side presents their case, and you may be surprised that that third party, whether it's an arbitrator or a judge, prefers the other side's position. So you also, that's something to be mindful for, and be creative in working with counsel or a mediator to make sure that you craft decision that works best for your family, because the third party decision may not be something that you like. But let's touch a little bit and wrap this up. Sort of in some cases though, sole decision making responsibility is essential, correct? In high conflict
Absolutely.
cases.
Yeah, absolutely. Like I said, case by case, we would look at it, but there are just people that strictly don't get along. There's a lack of involvement, with respect to a decision. So one party needs to be able to make the decisions, and it is in the children's best interest because they need to have stability. They need these decisions to be made. And if there's a lack of involvement or willingness of one parent to either communicate those decisions effectively, reach any decision, fail to consider the needs of the children, it would be appropriate in that circumstance for one party to have final decision making. A lot of the time, decision making even could be just renewing passports, renewing government IDs that some people just don't want, to cooperate with,
Yeah. Okay, I want to be careful, Shireen. That's not really
I want to
the realm of
it's not a major decision, but just something along the lines of, someone even not be willing to just sign passports, be involved in any capacity, come to medical appointments, give the prescribed,
you need to add there that if you want to be able to get passports or documents signed and renewed without the other person's authorization, you need to remember to ask for that as a separate order though, because that's another one that has gotten a lot of people. So they have sole decision-making responsibilities, and then they're surprised that they're not able to travel with their child without consent, or they're not able to renew documentation. So I just want to be very clear on
Actually,
that.
that's a good point to add in. So if that is your situation and you are seeking, sole decision-making ability, please add in dispensing with the other party's consent to travel, to renew these government documents, because you would be surprised that your order for sole decision-making ability does not give you that authority.
Exactly. And then when you're, if you're the party that's, wanting to make sure that a joint regime is happening, you just want to think about the practicalities of it, right? If you're in a completely different time zone, for example, well, does it really make sense? What if an emergency happens? Again, that in and of itself is nothing. It's just something to think about, because generally if there's an emergency, it's expected that the parent will make the decision that's necessary and would inform the other person. So different time zones in and of itself is just not enough, but it just adds to the complexity when we're thinking about what's the best scenario to have for decision making. But another thing I wanted to touch on as well was parenting time. Like if you have very limited parenting time or almost no parenting time, and then you're fighting for decision-making responsibility, that's a real uphill battle.
Yes.
So, I mean, that again comes back to thinking about the practicalities of things, right? If you have a child for 1 weekend a month, and but again, it depends on the circumstances, right? Could it be because of the relationship with the child? Could it be because of your conduct, or it might just be because that's the arrangement that works best for the family. If you're a parent that's maybe offshore sometimes because of work, and that's the only arrangement that works, and you still want to be, involved in decision making, well, if we're being creative, well, we can take in some of what, like Shireen had mentioned, putting in timelines, so that if you're not able to get online quick enough to have a discussion with the other parent, then they should be able to make that decision and just not have the child in limbo. And then in other cases, obviously, where you're available, then you can give that input. Ultimately, at the end of the day, it's what's best for the child. I personally think having two opinions is best. But sometimes no, sometimes you really do need one person to have that final say, and the circumstances of your case is really what would dictate what happens.
Yeah, actually, I just wanted to, you touched on something that kind of struck up an issue that I see a lot of people confusing day-to-day decisions with major decisions. Just because you have sole decision-making ability would not be able to, like, you know, dictate what the other person gets to do on their parenting time. A lot of the time, that's a point of confusion. It's really, the parent decision-making is really only important decisions. And those, for the most part, can fall under, you know, 4 categories that I mentioned: the education, religion, health decisions, and Section 7 is significant Section 7 expenses. So for the most part, the other decisions, those day-to-day, like pickups, drop-offs, you know, how long the child gets to watch TV, when they go to
eat,
what they eat. A lot of the time people think that that's going to be what they're going to be able to control. And unfortunately, that's not the case. So I think just maybe, you know, making sure that you're aware of what those are, what the decisions are, and maybe even looking at your scenario from, you know, an outside perspective as much as possible to say, okay, you know what, this is how old our kids are. These are the decisions that we've had to make. This is the point of contention. And you'd be surprised that most of the time, your contention is usually not the major decisions. It's those day-to-day decisions. So just being focused on what the key areas between the contention actually is, you might be able to better narrow down and focus on resolving, hopefully, the issues.
That's a very, very good point. And please don't make the mistake of just saying, well, there's 4 areas. Shirin's just rattled up these 4 areas multiple times. So we're just going to split it. You will take education and religion, and I'll take medical and, you know, extracurricular activities. Just remember that they all intersect. You know, a child's ability to participate in certain activities could be tied into their medical conditions, right? So let's even recently look at when we had the air, I don't even know, the smoke and all of that was happening in the GTA. Well, if you say, well, and let's say you have a child with asthma, if you say, well, I have, you know, the final say over extracurricular activities, I'm going to send this child outside to play, but, you know, the other parent has final say on medical, well, you can just see how very quickly that, you know, it intersects, right? So it's a whole being we're talking about, not just.
Yeah, another cross example is, you know, therapy. Yes, it's medical, but it also hinges on significant Section 7 expenses. So it's one of those things that you really it could go hand in hand, depending on how people interpret it. But there's been a lot of issues with interpretations of orders as to, okay, if it falls under medical, it technically also falls under, you know, extracurriculars, because it was, I mean, in this.
Or it might be education. It might be, so.
Like a psychoeducation assessment, like all of those are different factors that you have to look at. Yeah. So I think if you are doing a parallel parenting or split decision-making, it needs to be crafted well and with intention, because it can have a lot of unintended consequences. And probably hurt you more than help you if it's not drafted, you know, in a very specific way or detailed enough to make sure that you don't fall into these pitfalls.
Absolutely. All right. I think we've covered that a little bit. There's a lot more we can add, but I think we've covered the basics, so to speak, right?
Yeah, I think so too. So please feel free to reach out to us if you ever do have questions or concerns about, you know, how to best approach your situation and, you know, crafting, you know, what makes sense in your situation. So
absolutely. All right. Bye for now.